right.
Little
Okay,
technical.
good morning. Welcome to another oral argument session of the Fifth District Court of Appeal by Zoom. I'm Judge Brian Lambert. I'll be presiding today. This case is 5D20-1210 Federated National Insurance Company versus Ronald Basinski. I apologize if I'm mispronouncing that. Our panel today includes myself and Judge Edwards, and we're pleased to have as an associate judge sitting with us this week, Brian Duckworth. Judge Duckworth is a county court judge in Orange County. This is his first time visiting with us as an associate judge. So we appreciated the help that he's given us this week. You see the clock in the upper left-hand corner. Each side will have 20 minutes. We'll give the appellant 5 minutes rebuttal unless Ms. Bellis, you tell us you want something different. Then the marshal who's keeping track of the clock will adjust it accordingly. We are being live streamed on YouTube, so with our vast following of watchers for these oral arguments, just keep that in mind when you make any comments to our an argument. Also, if you have any type of electronic devices or phones or whatever that are on, please either turn them off or put them in a silent mode so that they don't distract either your opposing counsel or the court during the oral argument. All right, that said, counsel for the appellant, when you're ready to proceed, you may go ahead.
Thank you, Your Honor, and good morning. Karen Bellis of Kubicki Draper for the appellant, Federated National Insurance Company. I would like to reserve the 5 minutes Your Honor mentioned for rebuttal. So in this case, it is Federated National's position that the trial court erred in awarding the plaintiff a final judgment for interest, despite essentially two reasons. There is a final judgment and a verdict for the defense. So there is a $0 award in this breach of contract Hurricane Matthew claim. Secondly, the court erred in allowing the timing of FedNat's payment of a CRN cure meant to pay and absolve FedNat of any potential bad faith action to be presented to the jury, again, in this breach of contract damages matter. And that ultimately led the trial court to err in giving the jury a question, which it explained was not a verdict, but rather seeking guidance on whether FedNat's payments on the claim was untimely, and then using that payment to award interest for the plaintiff under 627-701-315 Florida statutes. As we've laid out in our briefs, plaintiff is not entitled to prejudgment interest on the verdict, which is what the judgment for interest says it is for, because there was a $0 award, a defense verdict, and actually a judgment for the defense that has been entered on that. Again, this is a first party claim for hurricane damages. There was a lawsuit filed, and months after filing the suit, the plaintiff filed a CRN under 624-155, Florida's bad faith claims administration statute, that gives FedNat a 60-day safe harbor period to cure the violations contained therein by paying all contractual damages under the contract that they believe are owed. FedNat responded within 60 days by making a payment in a letter dated November 9th, 2017, of $59,241.29. That said, it was a cure for any and all damages that may be covered under the policy, including replacement of the roof, the pool enclosure, and ensuing damages it believes was covered in the interior. FedNat maintained that there was no coverage for a dock and a seawall. As the record makes clear, this $59,000 represents not only the $59,000 check, but becomes $65,841 and change when the $6,600 hurricane deductible is added in. So FedNat made a payment in order to cure the CRN essentially of $65,000. once they made that payment and cured the CRN, that contractual amount owed, anything related to liability for that contractual amount for the breach of contract case, which is what we are here before today and what was before the trial court, is cured. It's relieved of liability for that contractual amount. The law is clear that when curing a CRN, extra contractual damages such as interest are not necessary to be paid. We cite a bunch of case law that you don't have to pay everything the plaintiff requests, that it's only contractual damages, because the purpose of the statute, the bad faith statute, is to encourage payment of the underlying claim. Again, we're here on the underlying claim, and avoid unnecessary litigation. So you don't have to pay damages that are not recoverable under the contract. And we cite the Manor House case, the Bayman case in our brief. So again, once the CRN was paid, Brzezinski had waived by serving the CRN, asking for the payment, allowing the opportunity for FedNet to cure by payment. They waived any right to interest, extra contractual damages, including late payment interest or delayed damages interest, such as those under 627, 701, 315, which is what the interest award here. It took the risk that FedNet would pay. FedNet did, so those damages are gone. So what actually happened here, and what the plaintiff is doing and admits at page 3 of the brief, is that plaintiff is attempting to get an interest award on the prior payments of a CRN in order to support an award of attorney's fees in this first party case under 627-428. We lay out in the briefs that this is not permissible in the law. It's not permissible under 624-155. It would be similar to an appraisal award, the Silber case and the Esposito case that we cite, in confirming, which was denied. They moved for a confession that was denied here. They have not appealed that. It would be like confirming a prior award in order to get fees. And it would be tying extra contractual damages to the payment of a cure. And that's just not allowed. And in fact, what happened here, what they're not happy with, is both parties went to trial asking for, we said that we had paid more than enough damages. The plaintiff presented various witnesses, including Ms. Jurgen, to say, oh no, even on the things you paid, you did not pay enough. You should pay $100,000 of interior, not just $43,000. Unknowingly, because the jury wasn't given the words bad faith, but unknowingly what the jury did was confirm that FedNet's payment, again, of the $65,000 when everything is added up, the cure payment was correct. And that FedNet had paid all damages owed under the contract. So the only question relevant, and what they answered, was on the main verdict form, did plaintiff prove by the greater weight of evidence that the property sustained covered Hurricane Matthew damages in excess of $65,000, $65,841.59. The jury said no. That should have been the end of the case and the defense verdict. The cure is not a confession. It's not, this prepayment is not a basis for interest. And there's a $0 award for damages. So there's no amount of prejudgment interest owed, which is the only thing that was pled. There's also no basis for interest under 627 because it's premised on the ability to get prejudgment interest. So turning to the next issue, plaintiff is also not entitled to statutory late payment interest here because he failed to plead a claim for that interest under 627-7315 in the complaint. We've laid out in our briefs that it is improper, a violation of due process, to allow a case to go to the jury on something that wasn't pled. It wasn't pled. Plain and simple, it wasn't pled. So even if there had been no cure payment, plaintiff's pleadings would have been insufficient to get this type of interest. Again, because this is like a penalty. It is not just the prejudgment interest that attaches to a judgment, which again, they can't get here because there's $0, but the Argonaut case, the Bologna case, cited in our briefs versus Belladonna, go on to talk about the difference between a punishment type of interest that needs to be pled. They don't go into the pleading, but conceptually, interest that is purely pecuniary and something that is more of a penalty. This is a
Counsel, why would they have to plead for prejudgment interest? They don't have to plead for it in the regular claim of prejudgment interest. And secondly, what's the difference between the prejudgment interest, the common law and the one we're talking about now?
So the statute lays out the difference. And the statute 6277013 on its face says that it is different. It defines that there are two types of interest and that the plaintiff under the statute has to select which one it wants to seek. So the plaintiff didn't select that. Instead, the only thing plaintiff selected in their complaint was regular prejudgment interest. And so they're bound by that, which they cannot get because there's a $0 verdict. The difference here is the timing of things. This is not a pecuniary type of interest that just attaches to the regular judgment, which again, there's no judgment, so you can't have regular prejudgment interest. This is a punishment type, and it defines and requires findings as to when it begins, when there was a late payment. But again, it prohibits, it's also different because and on its face, it prohibits a standalone claim. So it isn't just regular prejudgment interest. It says you have to choose, and it says, and the Silver case does a nice job of talking about this, that failure to comply with this subsection does not create the sole basis for a private cause of action. So you can't get it if you haven't pled it in throughout. Also, it also is conditioned upon, it says, if there is a right to prejudgment interest, you must select whether to get interest under this section here, the timing punishment section here for late payment, or regular prejudgment interest. So there is a difference. But here, there's no basis under each, because if you don't have a right to prejudgment interest because you don't have a defense verdict, you don't have a right to interest here. And again, the Silver case goes through why you cannot confirm, award interest based on a prior prepaid interest award or appraisal award in that case. And this is similar to an appraisal. The CRN cure payment, again, is like appraisal in that it encourages.
Let me ask this. The verdict form seems to inure to your side's benefit. What if it was just a standard verdict form that says, was there a breach of the contract? Yes. How much was the damages? Whatever the number is, 65,000 in the verdict. Then I guess post trial, you would then ask for a set off saying, well, we already paid all this amount and should get a judgment for zero. In that scenario, there'd be no interest, right? Or would there be?
Your Honor. Correct, Your Honor. And though the question was somewhat flipped on its head, this is something I do see in a lot of these first party cases where there's a dispute about the amount of damages. The parties agreed that the amount should come in. And the question that went, the first question, which then later asked for more damages and other types of damages. The first question on the verdict form, did plaintiff prove by the greater weight of evidence that the property sustained covered Hurricane Matthew damage in excess of $65,000 and change? And they answered no. Upon that, the trial court entered final judgment for the defendant. And we shouldn't be here because that should be the end of the case, just as it would be had that amount been a set off. But in these first party cases, I do see that there is the amount often goes to the jury. But so any way you slice it, there's just no right to interest here, be it by the statute or regular prejudgment interest. And this all came about because for the same reasons that the cure was not a payment of the breach of contract claim and goes only to show delay damage, delay tactics, bad faith practice, claims handling type damages that weren't admissible. This evidence and this question simply should never have gone to the jury because the only question that was relevant to the jury is that first question I just read on the verdict form. And what happened then was that it led the trial court to err further post-trial based on the plaintiff's ultimate post-trial motion, which again, he admits is a setup to try to get attorney's fees under 627-428. It led, despite the defense verdict, it led to the question being presented to the jury. And then this interest award being awarded based upon simply inadmissible evidence. And essentially what happened, if you look at the big picture here, is the judge allowed bad faith type evidence to come in, delay tactic evidence to come in, bad faith cure to come in, and then allowed this part of that case to be tried, which is contrary to all of the bad faith law cited in our brief, within the damages claim. So we would request that this court reverse the final judgment for interest, and then there would be a defense verdict, defense final judgment. I'll reserve the rest of my time for rebuttal if the court has no questions.
Any questions? No? All right, Mr. Struble, your turn, sir, whenever you're ready.
Okay, thank you. Good morning. Matthew Struble for the appellee, Ronald Pojinski. The payment referenced here, the $59,000 payment issued by Federated National, that was issued at 395 days after Federated National received notice of the claim.
When you say the claim, there was more than one claim, correct?
Correct. There was a claim, initial claim was submitted on October 10, 2016. And then a supplemental claim was submitted on January 17, 2017. And
under the October claim, didn't the jury essentially find by its verdict that what you requested in the October claim, or what your clients had requested in the October claim, either was not covered or did not exceed the deductible?
No, because the Federated National denied the claim in its totality. About 8 months later, we filed the lawsuit. Our complaint specifically requested replacement of the roof, said that they wrongfully denied coverage for replacement of the roof. They asserted 9 affirmative.
Did the October claim seek replacement of the roof?
The insured was unrepresented at that time.
Yes or no? Yes or no?
I wouldn't say that was specifically presented. The insured would not have been able to do that.
Okay, my understanding was the October claim was for a relatively small amount of money compared to the later claim, and that the response from the insurance company was the dock's not covered and the seawall's not covered and the rest of your damages are below your deductible, therefore we don't owe you anything. Is that right or wrong?
No, that's correct. Yes.
Okay, so how in the world could, accepting all your other arguments, how could prejudgment interest or interest under the statute run all the way back to the first claim when the insured was not at that point making a claim for any damages above the deductible?
Because we also proved that the statute says that you can also apply it to when the supplemental claim is submitted. And the evidence showed a supplemental claim was submitted on January 7, 2017, that multiple follow-ups were sent to Federated National.
No, I understand that. But the judge awarded prejudgment interest all the way back to October. I understand if he went back to the supplemental claim, whether it was January or February, however you want to look at it, I can understand that. But how in the world can he go back to October? I don't get that at all.
Okay, so yes. So in terms of that and calculating the amount of interest, that was adjusted in the motion for interest. And yes, the statute says that you can go back to either the October 10th date when it was initially provided, or go back to the January 17th, 2017 date when the supplemental claim was provided. Federated National, when those motions were filed, could have argued that the interest amount should have been slightly less because it should have been calculated from the January 17th, 2017 date instead. But we laid it all out. They never took that position. They never made that argument, and they never argued that it should have been calculated from the January 17th date instead of the October 10th date. Instead, they actually paid the interest amount. That didn't dispute it, and they've actually paid that interest amount. They're just still appealing the case.
I have another question for you. How do you get prejudgment interest when you didn't get a judgment in your favor?
Because you go to the statute specifically that relates to this, and what was at issue in this case, 627.70131 provides that if a payment is issued after 90 days of receiving notice of the claim or the supplemental claim, that at the time that payment is issued, so when the $59,000 payment was issued, Federated National was required to pay interest with that payment.
Okay, so you're saying you're entitled to the statutory interest, correct?
Correct.
Okay, and the statute itself treats the prejudgment interest and statutory interest as two different things. It says you can choose prejudgment interest or you can choose statutory interest, correct?
Yep, so that goes in when you're calculating the date, as you indicated, and then that's addressed in the motion for interest when we did, and at that point, we selected
Right, so you agree then that you're not entitled to prejudgment interest as a generic matter, you're only entitled to the statutory interest.
Yeah, statutory interest, but as all the case law shows, statutory interest it's a pecuniary damage. The case law is very clear. Statutory interest in totality does not have to be pled at all. And we actually did plead prejudgment interest, even though we were not required to.
Well, you're not entitled to, you've already admitted you're not entitled to prejudgment interest generically. So that whole body of law doesn't apply. You're seeking specifically interest under the statute, correct?
Yes, Judge. And what the cases say is, number one, you don't have to identify the statute that the interest requirement is being requested upon. And one of the cases we cite too, they cite an old case, Stockham, that relates to fees and costs. And other cases explain that unlike a request for attorney's fees, nothing in statutes or case law requires any specific pleading by a movement for statutory interest. That's FIAD 676 SO.2D 1062. So all the case law that is there specifically says there's no requirement to plead a statutory basis for prejudgment interest.
Go ahead.
Okay, just on that factor, and I wanted to point this out. So we cited a number of cases making it very clear that there's no requirement to plead interest because it's a pecuniary damage that's determined by the court. Typically, it's addressed post-verdict. Here, the difference was, in this case, Federated National issued the $60,000 payment, but they took the position that they were not required to pay interest because there were factors outside of its control that prevented it from issuing payment within 90 days. That was the issue that was tried, and they presented their arguments to the jury. They tried to explain why there was factors outside of their control. There was substantial evidence showing the opposite, including that they received the supplemental claim, and then they didn't even ask an adjuster to go inspect until 108 days later, after a lawsuit was filed and after the 90 days expired. So the jury heard evidence that they received the supplemental claim, 100 days passed, and they didn't do a single claim on the single act on the claim to adjust it. So the way for Federated National, they contended that there was factors outside of their control. That's why they did not have to pay the interest on the claim. And all the evidence that was presented at trial was submitted to the contrary. That issue was submitted to the jury. I cited a number of federal court cases recently, which went through how that is the proper manner for that to be determined, because it is a factual issue. And that was submitted to the jury, and the jury determined that there were no excuses for that payment being untimely. And that was found by the jury to be a fact. So based on that, it was established as a matter of law that they were required to pay interest. Then after that, it was calculated. They didn't raise any objections to the amount that was calculated, and they have paid that amount for interest. As it relates to the arguments pertaining to a civil remedy notice that are raised.
Let me ask you this before you get off into that. Let's say the verdict form had simply said, did the plaintiff prove by the greater weight of the evidence that the property obtained, there was a breach? Yes. How much is the damages? And the jury came back $15,000. All right. So now then post verdict, you've already gotten $59,000 or whatever the number is. You would still, in your view, be entitled to interest on the $15,000 that should have been paid back in. We'll use your October. I mean, I agree with Judge Edwards, but let's use your October date for some consistency here. You would be entitled to interest on that, even though there had been an overpayment.
Is the 15,000 above? You're
No,
saying the 50,000 under?
You didn't have the threshold. You just had a standard verdict form. Did the plaintiff prove the defendant breached the contract, for lack of a better term? Yes.
Right.
The jury answers yes. Question, all right, go to question 2. How much are the damages? The jury says 15,000. That's the end of the verdict form. They sign it and off we go. So then post verdict, Federated National said, well, you ought to enter a judgment in my favor or its favor, Judge, because we already paid him 59 grand. So obviously we get a set off for that. And you did. So now now if I'm understanding, you would say, even though in that scenario, you would still go back and ask for, get prejudgment interest under the statute, under the 15 grand that hadn't been paid in the first 90 days of use your initial October date?
Yes, because in our scenario, in our facts, they didn't pay $59,000 on the claim. They denied the claim. They received a supplemental claim. They failed to issue dope payments.
You got paid somewhere along the line. I mean, that's obviously why the number's there, right?
Correct, but that's all. The cases where the only cases that say interest should not be awarded are the cases where the insurance company admits coverage right away. They send the claim to appraisal. The case is in appraisal being adjusted, and then a lawyer files a lawsuit, and then they say that lawsuit was unnecessary, so interest is not awarded.
So your answer to my question is then yes, you should get interest on the $15,000 that should have been paid according to the jury verdict, even though it was paid, there was 59,000 or 50,000 or some higher number paid.
No, there wouldn't be interest on the 15,000. What I'm saying is if it's like our case where that 59,000 was paid post suit, then they're required to pay interest on that unless they prove there was factors outside of their control that prevented them from timely issuing payment.
Well, maybe I'm just asking a poor question. I apologize. I mean, you got paid here the 59,000. You're saying it's untimely, and therefore you're entitled to interest, and the trial judge believed you. I'm saying let's assume that you got paid the 59,000. You all went to trial. The verdict form was different, and the verdict comes back and says the only damages you proved was $10,000. So then post-verdict, the Federated National would say, well, don't enter a judgment for 10 grand in their favor, Judge, because we've already paid 59 grand. And you'd agree that would be correct, right?
That sounds correct, yes.
Okay.
As to that, but the other issue would be that the jury also has to be asked, was that 59,000 paid that they're getting a set off for, was that paid timely? And if it was paid untimely, did they prove that there was factors outside of their control that prevented them from timely issuing payment?
But you wouldn't get interest on the 59 grand if the jury only found that you were damaged $10,000, right?
You would if they paid it post suit.
Well, then
I guess I'm just asking a bad question. Go ahead. I don't want to take up your time.
Okay, I would just.
Let me just hit you with one more. Excuse me. Let me just hit you with one more. The factors beyond the control, that's all part of that 627-701-31 5A statute, correct?
Correct.
Which you didn't plead. I mean, and again, I think that goes to their due process argument that if you had pled you were seeking interest under there, they would have been ready then to come back and show in better way, a more strident way that there were factors outside their control. And, you know, they claim surprise based on that. How do you respond to that before we hear it on rebuttal?
My response to that is on January 2nd, 2019, it's on the record on page 1631. They filed a lengthy pretrial motion citing 627.7013. It was FedNat that raised that issue. They argued that they were not, the payment was not untimely because there was factors beyond their control. We filed a response to that, citing facts that showed that they should have issued the payment timely. That was on January 17th, 2019, starting on the record 2173. And then they filed a reply on January 22nd, 2019, about a 15-page motion discussing 627.7013 and citing 14 pages of facts, arguing that the factors were outside of their control, and then therefore that statute did not apply and that they should not be required to be found to have issued that payment untimely. So it was lengthily briefed prior to trial. It was raised by the defendants themselves. They argued that based on that statute, there was factors outside of their control. There was conflicting evidence. So that evidence was submitted to the jury to determine whether or not there was actually indeed factors outside of their control or not.
So they were clearly on notice then, in your opinion, that if they lost their motion in limine or lost their argument that the interest and timing of the payment shouldn't come in, they were on notice of what they may need to prove, correct?
Yes, if you look at the statute, it says you're entitled to pay interest unless you prove there's factors outside of your control. And that's what they argued pre-suit. They said, hey, there was factors outside of our control. That went to a jury. Multiple witnesses testified as to that. And then it was submitted to the jury as a question. They didn't propose any alternative instructions, and the jury found that there were no factors outside their control and the payment was untimely.
Okay, thank you.
Based on those arguments and those set forth in our brief, we would ask that the court affirm the trial court's judgment in this case.
All right. Thank you, counsel.
Thank you.
Thank you.
I'm sorry.
Sorry.
You just have under 6 minutes in rebuttal. Go ahead.
Thank you. And I'd like to start with this notice issue that was just raised in the discussion with Judge Edwards. I must ask the court to take a look at the motions that the other side described, because we did not argue anything under the interest portion of 627-7013 subsection 5. As we explained in our reply brief, our motions that were just mentioned by the opposition cited only to the statute. This interest piece is a later piece, subsection 5. The statute itself is actually called Insurer's Duty to Communicate Regarding Claims, and it speaks to the 90-day issue. And the whole point of our motion wasn't opposing interest, wasn't thinking we were going to get hit with interest based on a prior payment like a confession or a prior confirmation of an appraisal award or punished for making a CRN cure payment. We were arguing from page 370 through the end of trial, including jury instructions. Timing had no place. We only referenced the statute as the 90-day issue having no place. We don't get into interest. We're not on notice that they're seeking this type of interest. So I would like to correct that for the court, and we do explain that in our motion. From start to finish, we sought, including these motions were denied that the timing should be kept out pre-trial. They were argued then on the first day of trial, and we lost. Therefore, my client was hamstrung because they couldn't introduce CRN. That would be introducing the bad faith. So they kind of had to dance around and put on some bit of evidence. But as Your Honor recognized, had they known they were going to get punished for a prior cure payment, they might have chosen to put on more evidence, to oppose this interest pre-trial, to put on the type of evidence that you have to put on in a bad faith case if you're getting hit with delay tactic damage. So I would correct that and disagree with that. As Your Honor recognized, Judge Edwards, this was a second claim. The first claim was for minor exterior damage, not a roof, dock and seawall damage, and no interior damage. There was a conversation, and the phone call was actually read to the jury that there was no interior damage and only minor exterior. This claim was not denied. Rather, it was found to be under the $6,600 deductible. And as we've discussed multiple ways here, there's simply no right to prejudgment interest, any way you slice it, under the verdict that found no damages were awarded because FedNat had paid $59,000, actually $65,000. So we can't get prejudgment interest. There's also no right under 627-701315 because it's tied to the rights to have prejudgment interest. So if you have no prejudgment interest, you can't get that. Plus, again, for the reasons I just explained, we weren't on notice of it. And I do believe it has to be pled. Even though it's not discussed, there's no case law saying that yet, we do discuss that this is more like a statutory penalty, like attorney's fees. And if you look to the Argonaut case, which finds that regular interest simply is a matter of law, an element of pecuniary damages, they talk about the difference where there's a penalty. And we have argued that this is a penalty that must be pled. We went into trial having no idea that we were going to be hit for interest on something we paid. Again, that would be punishment, penalty, and also completely contrary to the purpose of 624-155 and making a cure payment, because then why would a carrier ever cure that within the 60 days a bad faith civil remedies notice by making a payment if they're still going to get hit with interest? They can't be. Again, all of the law on bad faith makes it clear that extra contractual damages interest are bad faith. And opposing counsel started here by talking about 295 days and 200 days and whatever the days were, they're not relevant. The relevant facts for this breach of contract case are only that we paid more or enough than was owed under the policy, and the jury agreed with us. So there's no basis for interest. And again, the cure payment and its timing is a bad faith issue. Never should have been here, never should have been introduced, never should have been a guidance question asked by the jury. It's just simply not permitted here, because what happened was then that cure payment is contrary to this, to the purpose of 624155, was actually used to punish my client. They didn't get, cure their bad faith. They had this judge decide the bad faith within the context of the breach of contract action, and that's simply not allowed. And again, it would be like confirming an arbitration award and then allowing fees based on a previously paid good faith attempt to avoid litigation. So for all of those reasons, we would request that the court reverse the final judgment for interest and allow the main verdict and other judgment that is in favor of the defendant to stand by vacating the interest award. Thank you.
Okay, all right. Thank you, counsel. We'll take this matter under advisement and we'll be adjourned. Judges, I'll call you in a minute or so. All right, have a good day.
Thank you.
Thank you.